thank you all. I think that Professor Bowries doesn't appreciate how much the last concession about Klein has given away the game. Concedes that a prosecution of a former president for exercising the pardon power, or presumably any other power that is within the president's conclusive and preclusive authority, would be unconstitutional, despite the fact that there is no presidential immunity clause, despite the fact that all of the Federalist Papers that he references say what they say, and the history says what it said. And I'll get to some of that in a moment. But the point of the concession about Klein is that we recognize that the president cannot be prosecuted for at least some official acts. If we really believed the text and history argument that had been advanced, the implication of that would be that there is no immunity whatsoever. Once we conclude that there is some immunity, then the absence of an explicit presidential immunity clause can't be decisive. Instead, what we realize is that the immunity, if we want to call it that, is really a misnomer, as Justice Barrett said in her concurrence. All it is an inference from the separation of powers. That giving the president certain authority carries with it implicitly the guarantee that the president will not be prosecuted for exercising those powers. Same thing is true with respect to some other points that Professor Bowries referenced. Among them, the Ford pardon, the Clinton non-prosecution agreement, and so forth. Everybody concedes that there are some prosecutions that are okay. Some prosecutions of a former president are okay. The court in this case says there's no immunity whatsoever if we're talking about unofficial acts. So if there is no plausible claim that the president's behavior was within his constitutional authority, then there's no immunity at all. And if there are some cases then where there's no immunity, well then, of course the impeachment judgments clause means that we can prosecute the president after he leaves office, even if he is impeached and convicted. And of course, President Ford should be able to pardon President Nixon, and that carries some kind of meaning because we recognize that Nixon would have been able to be prosecuted at least for unofficial acts. The history is unavoidably ambiguous here. Yes, it's true, we haven't explicitly said that the president has criminal immunity from prosecution until now. But of course, there hasn't been a criminal prosecution of a former president, and so the issue hasn't come up. The injunctions point that Professor Bowries raises, again, I think it cuts against him. We recognize that, yes, we can sue under Ex parte Young or what have you for injunctive relief. If somebody says, the administration is violating my rights, I have a right under the Constitution or under a statute to be treated a certain way, and the administration is not treating me that way, we can get an injunction. We can sue an official in his official capacity for an injunction. Well, that means that someone whose rights have been violated has a remedy in court. The only question here is whether we have this additional option of going into court after the president left office, after he can't do anything for this person anymore, and punishing him criminally for it. And a final point. Some of President Trump's behaviors were unquestionably terrible. I'm not defending his behavior. I'm not defending his arguments in court. I think you are quite correct that the argument that his lawyers made that he would have to be first convicted in an impeachment before later tried was a terrible argument. It was a frivolous argument. It lost 9-0 at the Supreme Court. What I'm here to defend is the decision that the Supreme Court actually reached. And so the question before you is, did the Supreme Court grant too much immunity? We don't know yet how the Supreme Court's decision is going to apply to Trump's case itself. The Supreme Court left almost all of those questions open. And just within the last week or so, the special prosecutor filed a brief that argued that almost all of the actions that President Trump engaged in after the 2020 election could be the subject of prosecution, notwithstanding the Supreme Court's decision. So, if you think that prosecuting President Trump is appropriate, that his behavior goes far beyond any claim of lawful authority, the problem isn't with what the Supreme Court said. It's with what Trump is arguing, and maybe is still arguing. But the question before the House is whether the Supreme Court granted too much immunity. The Supreme Court didn't declare President Trump immune from any of those things except for a conversation between the President and his own Attorney General. And if you think that Congress or the courts can intervene within the executive branch to make criminal a conversation between the President and the Attorney General, then you don't appreciate the value of the separation of powers system that the framers put into the Constitution. I thank you very much for your attention. I urge you to vote no on the proposition.